What's up, everybody? Welcome back into the episode of the Lawyer You Know podcast. And we are gearing up for the next trial we're going to be covering, which is Brian Walshe in, you may have guessed it, Norfolk County. A bunch of pretrial motions were filed. This is going to be our gear up point to get ready for this trial. And there are some very major decisions that are going to be made by the judge in this case that can have a profound effect on the outcome of the case. There's certain pieces of evidence that the state wants in and the defense wants out that if they do come in, there are certain percentages done by the research that absolutely say it is very likely to be a certain result, regardless of the rules, regardless of everybody's rights. And we're going to break down some of those motions and give you an overview of everything that was filed and what we think is going to happen, whether it's a big deal, whether it's not, whether it's just your average run-of-the-mill motion, or if it is something very specific to this case. Make sure you guys hit that like button. And I said we throughout this intro because my dad is coming on to join me. He knows almost nothing about the Brian Walshe case, but he's going to tell you the legal takes on what usually happens in cases like these when motions like these are filed as we go in to yet another trial. Let's get to it. Welcome back, Dad, to yet another case in Norfolk County with some names you may recognize as we watch this trial, but you're coming in pretty fresh to these motions. You know what the charges are. You know there's a federal charge, a state charge, not necessarily connected, but maybe. We'll get to that motion a little bit later. But it is yet another criminal defense case with the most significant charges you can have and the most significant allegations you can have. They did file a motion to change venue as well because of how much publicity this case is getting and just how graphic and how everybody seems to be interested in this case because of how wild the charges are, wild the accusations are, and then, of course, Norfolk County. But we had 30-something motions filed, which is not that unusual right before a case happens. It's supposed to go to trial on October 20th. At least that's when jury selection is going to start. Because there is a change of venue, maybe jury selection could take a little bit longer since the defense obviously feels like they're not going to have the ability to pick a fair and impartial jury. But knowing that Karen Reed had not one but two trials here and was able to pick a jury, what are just kind of your quick thoughts on a motion to change venue by the defense with a case like this that you've never really even heard of, which should tell the world something as far as comparing this to Karen Reed?
Yeah, they're going to get a jury. And I don't think that they're going to get a change of venue. Like I said, this case, compared to Karen Reed's publicity, really, there's no comparison. I think they're going to get a jury. They're not going to get a change of venue.
And I think it's also like not just how many eyes and how much interest there was in Karen Reed's case, but it was years and years and years of multiple trials. This one has ramped up more since the Karen Reed case. It was a lot in the beginning and then a lot more since the Karen Reed case, but we'll see what the judge says. Yeah, I would think that that they're going to be able to get a jury as well. But let's get to some of these pretrial motions. And the way we're going to handle these is we're going to burn through a bunch of the smaller ones, give you our takes, summarize them, and then we're really going to dig into a couple of these significant ones that are different for this case and we think will have the biggest effect on the outcome of the trial depending on what the judge decides. The first one is just a motion to use something other than Zoom. There have been some issues in the past. They want the judge to be able to have appropriate control. And this is basically something that's common sense that the lawyers want to use to make sure that this trial gets handled appropriately, knowing that people are going to be streaming it. Any issue with this motion?
No, and I don't see how the defense is going to, in good faith, object to the motion. So yeah, it's going to get granted.
It's something that they should both want, frankly. Right. The next one is the Commonwealth's motion for the jury not to see demonstrators, basically. And again, they cite Karen Reed's case. There may be demonstrators outside against law enforcement. There may be demonstrators against Brian Walshe as well. This is one of the reasons I also thought maybe the defense shouldn't want to change venue. What do you think the judge will decide here?
I think the judge may want to put this one off a little bit until he sees whether or not there really are demonstrators and there really is a need for doing this. Because again, this is a First Amendment issue. And the judge doesn't want to do it unless there's a real reason. So I think he's going to, or she, I don't know if it's a he or a she, that's the judge.
I think it's a he.
Is it? I think that he is going to want to have some facts to back up his decision before he enters a ruling on this.
Yeah, and I've watched a couple of the pretrial hearings on Walshe, but I still come into it pretty fresh. I know some of the background. I remember some of the articles immediately when the case came out. But this is going to be a good one to go into and just kind of see how it's presented, see how they present the investigation. What did the cops do? Did they drop the ball? or is there really a mountain of evidence, which it seems like from all of the hearings that I've seen, but I'm going into it pretty fresh, not like Karen Reed round 2, where, basically we knew everything about it before the trial even started. I think the judge should say no to this unless there is a major issue, again, citing the First Amendment and other reasons why. The next one is a motion to allow the jurors to use laptops and other devices to view evidence. That's very common. It's allowed in basically every case. Both sides should agree to that. Any issue with that one?
No issue with that.
Next is the motion, Commonwealth's motion for the defense to basically show them everything they plan on using in an opening statement because it's not going to be evidence yet. Another thing that is very common, another thing that should be reciprocal, where both sides should show, I'm going to use this exhibit, I'm going to, play this video or audio tape in opening. And again, most of the times, like, we know this is going to come in. If we don't think it's going to come in, let's argue about it now, have the judge make a decision now because if it is really important for the defense's opening, they should be able to use it in opening. If the state has arguments, then fine. Sometimes judges will reserve ruling on certain things to see how the evidence comes out in trial. But this is this is almost one of those, which we're going to say multiple times, asking the other side to follow the rules. Like, this rule already exists in order to get this done.
Right. And again, this is basic fairness. A lot of these motions are just the judge, let's just be fair. And we shouldn't have surprises here. We should be able to know what each side is going to do. And again, the judge is going to grant this.
The next one is the Commonwealth's motion for notice of any third-party culprit defense. This is another thing I believe the rules require notice of a third-party culprit defense. But I think the judge will grant this as well.
Yes. Do we have, again, I've read these motions and a lot of them are very vague and a lot of them really
they're kind of boilerplate. The more vague they are, the more boilerplate. We've had cases where prosecutors file 50 motions in limine on 2 pages because they're all just one line, like no hearsay should be able to come in, the rule of sequestration, no bad character evidence. It's like, these are just the rules. You don't have to file motions in limine for the rules, but sometimes they do.
Yeah. So, again, this is just a vague motion with no facts and really nothing to back it up. They're just putting the judge on notice. It's
not like the Karen Reed case where they're like, Judge, we think they're going to point the finger at X, Y, and Z. They need to tell us and show what evidence allows them to do that. The next one is motion limine to keep out improper character and reputation evidence. Again, that's already inadmissible, but just to highlight it, I guess, to make sure the judge knows they think this might be coming. Agreed?
Yeah, there's nothing there.
Yeah.
Again, nothing new.
Again, a motion to allow the in-court ID of the defendant. That's going to be granted. All right. The next one, that's going to be one that's probably something a lot of people are interested in, which is the Commonwealth's motion in limine to exclude irrelevant conduct of testifying and non-testifying police officers, basically, which is the big Proctor and Buchanan motion. They don't want Brian Walsh's team to be able to basically cross them on all of the things they did wrong in the Karen Reed case. What did you think about this motion? What stuck out to you, and how do you think the judge will rule here?
Well, one of the things that the prosecution knows is the defense does want to get into it, and the defense issued a subpoena for all of those records. So the defense is going to want to get into it, unless, again, same thing as in the Reed case, unless they can show that there's a direct relation that actually shows something relevant about the conduct. I don't think the judge is going to let it in. Just the fact that there was some study or something done that says they did a bad job. Well, that study's not going to get in because, again, it's reference to the Reed case, for one. Number two, it doesn't really intersect with this case. So they have to connect it up. If they can't, it won't get in. If they can, I think the judge is going to let it in.
Yeah, but there's also the credibility issue. And I think credibility is always an issue in every trial. Bias is an issue. I think if they can get into some of their prior testimony or inconsistencies or things they did to show that they maybe jump to conclusions on cases, they cut corners, they're willing to lie or misrepresent, or somebody said they didn't actually put what they put in their police report. I think there might be some creative ways to get into some of this prior, we'll call them prior bad acts by law enforcement officers in the Reed case. I think I would be open to allowing Walsh's defense team to attack the credibility of some of these, especially the testifying officers. I would say you can't do that for the non-testifying officers, but for the testifying officers, if you're going to come be a witness in this trial, your credibility is at issue, and I think they should be able to get into at least some of it.
I think it's got to be specific. I don't think they can just say, you're a lying police officer. I think there's got to be something that shows, well, you lied about this fact, and this fact relates to similar facts in this case. There's got to be some relationship. It's an uphill battle, I think, for the defense to get this in.
Yeah, I think I just feel like they'll find a way to at least get some of it in, so that these jurors know these officers have issues, basically. I don't know if it'll be Reed specific, but I do think they're going to be able to get some of it in some way, somehow. Next is the no bad character evidence for the victim. We already talked about, again, this is something that's generally a rule. There are certain cases, like if it's a self-defense case, that certain character evidence or characteristics of the victim can come in. It does not seem like any of that applies here.
No, and it's going to be a situation, again, a lot of these are really discretionary. A lot of it, I think the judge is going to have a tough time ruling today on what's going to happen during the trial. And I think this is one of them, is that, the judge might say, well, yes, it's true, bad character doesn't get in. It doesn't mean that he wouldn't reconsider it during the course of the trial if it becomes relevant for some reason. So again, this is going to be an advanced evidentiary ruling, but it's not cast in stone. Things could happen during the trial that change it.
Yeah, I think that's a really good point. Just because the judge says yes or grants one of these motions doesn't mean something couldn't come up in the trial that could affect some of these rulings, which is why, if that is something that could happen, a lot of judges will reserve ruling until the trial is actually happening and we see how the evidence is presented. Next is motion to introduce photos of electronic devices instead of the devices themselves. Any issues with that?
No big deal. You're going to grant it.
Especially because they've been downloaded and tested and there's experts and all that. Next one is, okay, this is the first one I want to read a little bit of. So let me pull this up. All right. So Dad, you tell me, can you see on the screen motion in limine number 9?
Let's see if I can expand it, but I mean, I know it, so.
I'm trying to make it a little bigger. There we go. All right. So motion limiting number 9 is the Commonwealth's motion to admit the defendant's 4 recorded interviews with police. The audio recordings and transcripts of these interviews were introduced at the hearing on defendant's motion to suppress the consent searches of digital devices. Interviews 1, 2, and 3 occurred at the defendant's Cohasset residence. Interview 4 occurred at the defendant's attorney's residence. A defendant's statements to police officers are generally admissible at trial. When statements are those of the defendant himself, they are admissible as admissions of a party opponent. An extrajudicial statement made by a party opponent is an exception to the rule against the introduction of hearsay and is admissible. So that's easy. The statements of the defendant are easy, but here's the interesting part. The defense attorney in the federal matter was present at the 3rd and 4th interviews, and most of her statements are also admissible. Statements authorized by a defendant or made by an agent of the defendant are not hearsay and are admissible as of those defendant. The attorney was present as the defendant's agent, and the statements she made during the recorded interviews were made in his presence. Even if the attorney is not deemed to be the defendant's agent at the interviews, the statements are also an admission to provide a complete picture of the defendant's statements to give context to certain remarks in the interviews. Attorney Miller represented the defendant at arraignment in Quincy District Court and was also counsel of record in this case prior to her withdrawal and the appearance of present counsel. So, what do you I mean, obviously the defendant's statements are going to come in. They always come in. What do you think about the defense attorney's statements?
All right. In theory, they are correct that a defense attorney can make a statement that is an adopted admission of a defendant. It happens all the time in court. Does your client wish to plead guilty? Yes, Your Honor, he wished to plead guilty. Well, the judge can rely on that as a statement of the defendant. However, one of the things you've got to look at these statements were these off-the-cuff statements that a defense lawyer may just, hey, we shouldn't talk anymore, or hey, we need to take a break, or are they actually admissions adopted by the defendant? That's going to come out clear during the course of the testimony and during the course of that tape, because my guess is those statements they're talking about are on the tape as well.
Right.
And so we'll be able to interpret those statements are they adopted admissions of the defendant, or is it something independently that the defense lawyer is saying and therefore not adopted by the defendant, but just the opinion of the defense lawyer? I say things all the time for my clients that my clients don't adopt everything that I say. Therefore, That's the only way it comes in, is if it's an adopted admission of the defendant that his defense lawyer said on his behalf or her behalf.
Fall seems to be hitting even in Florida as the weather turns just a bit, and it is probably my favorite season of the year, but it's also the busiest season of the year. And when things are busy, that's where our sponsor, Green Chef, comes in, because we still want to eat healthy meals and hearty meals for our family that fill us up, but still leave us feeling good and fresh and light on our feet. And Green Chef is also great for the entire family because they have 80 plus dietitian approved weekly meal options. They make it easy to find meals that fit your lifestyle, but also what your family likes. You can pick from Mediterranean, gluten-free, plant-based, and protein-heavy, even gut and brain health. And of course, calorie-smart choices too. The recipes change every week, so they will always keep you going with something fresh. So make this fall your healthiest yet with Green Chef. Head to greenchef.com/50LYK and use code 50LYK to get 50% off your first month, then 20% off for 2 months with free shipping. That's code 50LYK at greenchef.com/50LYK. Next one is the motion to admit missing person forms of the victim in this case. I don't see any issue with that. Do you?
No, I don't.
I guess depending on what's on them, right? We haven't seen them, so as long as there's nothing on them, that would be inadmissible. Next are to admit photos of how the victim appeared normally. And they made arguments that, maybe some things she was wearing or would wear in the past was found in dumpsters or with some DNA or bodily fluids on them. And that would be helpful for them to be able to use these pictures. What do you think about this one?
Well, this one is a blanket statement, bothers me because I wouldn't want, obviously it's sympathy creating. You put her on there, laughing, maybe exchanging Christmas presents with her, with her child. You've got things like that really shouldn't come in because they don't have any evidentiary value. If there's a picture, and they could do it by screenshot, I believe that there is a watch that she was wearing. I think that's one of the items. I don't know all of them, but I remember that particular item was a watch that she was wearing a couple days before she went missing. I think that could be relevant. But generally, just showing pictures of her, I don't think it's relevant. And their argument to me is, reading the motion, I didn't think their argument was very compelling by a lot of the videos and pictures they wanted to show. But the ones that have evidentiary value, like the one with that watch, I can see that one coming in.
Generally, I think the judge is going to grant this. I think if the defense has some specific reasons why some shouldn't come in, maybe they won't. But I think they're going to be able to get a lot of this in, personally. Next one is, okay, so this is the big one. So let me pull this one up. This is one we're going to read. It's about 12 pages. And as I read, Dad, you can interrupt me to give your thoughts. But the reason we're going to read this entire one, and I'll give my thoughts as we go too, obviously, is, to me, this is the single most important motion of the stack. The Proctor and Buchanan stuff, if they're able to cross them, fine. You can make the cops look bad. But, if they still have certain evidence, it's still going to make the defendant look bad, and the jury's going to have to make this decision. Do we think he actually did this? Research shows, and we know this by experience, anytime other bad acts / criminal charges / criminal convictions come up in a trial, whether we as the defense attorneys believe them to be relevant or not, the vast majority of criminal defendants that have this come up in a trial are convicted. The research amounts go up major percentage points that if they can introduce this evidence, the same thing if we remember back to Alec Murdaugh's case, when the financial crimes came in and he, admitted all of them on the stand after, the defense fought to keep them out. They all came in. We pretty much knew he was going to be cooked at that point. We have had cases again where we've fought to keep other bad acts and other criminal action out or potential criminal action, even if it was never charged. When it comes in, it is a very steep hill to climb. Would you agree this was potentially the most important motion filed in the stack?
It is definitely one of them. And, there's two ways it comes in. And one is the 404B evidence, and the other is inextricably intertwined in the case. And you'll see as you go through here that they address those issues. It's how it can come in.
Let's take a read here. So the summary of the relevant factual background. And this is something I didn't know about until reading this motion. I knew that these charges existed. I did not know the ins and outs of them. The defendant is charged with M, misleading police and unlawful conveyance of a human body. At the time of the offenses, the defendant lived in a rented Cohasset house with 3 young children he shared with his wife, victim Anna Walshe. Anna lived in Washington, D.C., where she had a highly compensated job at Tishman Speyer and commuted to Cohasset to spend time with the defendant and her children. Both the defendant and Anna expressed frustration with these arrangements, which began in the spring of 22 when Anna was hired by Tishman Speyer. The defendant had been unable to move to Washington, D.C. with Anna because of pending federal charges for wire fraud, interstate transportation for a scheme to defraud, and unlawful monetary transaction in the United States District Court for the District of Massachusetts, U.S. District Court for the District Court of Massachusetts. So just those charges, right? When a jury hears he's charged with, and usually they hear and guilty of, federal wire fraud, interstate transportation for a scheme to defraud, and unlawful monetary transactions, what do you think they think of a defendant?
Well, then they think he's a dirtbag. This guy's a dirtbag. I'm on this jury. I've never been arrested because obviously if you're a juror, you've never been convicted of a felony. So I'm a juror. I'm a really good person and honest person. Honest people don't do this kind of stuff. So, and especially if this guy's going to testify during the trial, they're going to say, why should we believe this guy? We know he's a fraudster.
If this comes in, he is, as the kids say, cooked.
Yeah.
Among other things, the federal docket report shows that the defendant was arrested on May 9th, 2018. Minor filed a notice of appearance. Defendant pled guilty on April 1st of 21, and sentencing had been repeatedly continued. At the time of the offenses, the defendant was awaiting sentencing. Defendant was awaiting sentencing subject to monitoring, and the government was requesting a committed sentence and hundreds of thousands of dollars in restitution. This is also interesting because if he were to testify, they would be able to ask him, have you ever been convicted of a felony and how many felonies? But they would, and actually, I guess they would be able, would they? No, they wouldn't be able to say the specific.
Generally speaking, just the number.
But they would be able to say it was a crime of dishonesty, because that's important. Usually when jurors hear it's not just a felony, but it's also a crime of dishonesty, which these would be, that's a big deal usually. They wouldn't know what the specific charges are, but they would know about the crime of dishonesty. And we'll talk about parsing that out here. If the judge allows this information to come in, does he have to allow it to be what the specific charges are? Or will the judge split the baby a little bit and say, there were pending federal criminal charges? Is that enough to get the information the state wants to get out there without damaging the defendant? Again, how prejudicial is this going to be?
Well, if you believe the state's argument that this is all part of the motive.
Well, we're going to get to that.
I know, but I'm just saying that's why it's critical.
The actual charges themselves, you're saying?
Right.
In December of 22, Minor was negotiating a disposition with federal authorities during recorded interviews with police after he reported that Anna left Cohasset on January 1st, 23 for a work emergency in D.C. The defendant told police that being apart was a stressor for them and that he had recently learned he was facing committed time on federal charges. During the interview, he stated that Anna, I keep saying Anna or Anna, it's probably Anna, right? Was upset at the thought of him going to federal prison for 6 months. The defendant said, after all of this, because we have been apart for so long, she's like, why do we do all of this house and running the townhouse and all the traveling this? Why do we struggle this much? I mean, the cost of and not being together. I remember her being very upset when I talked to her about it. The defendant owed significant restitution, which his attorney wanted him to pay as soon as possible. Meanwhile, Anna had expressed frustration with her children not being with her in Washington, D.C., and told a friend that she and the defendant had a big argument over Christmas when she told him he needed to take accountability for his crime and accept the committed sentence. Anna told the friend she had only recently learned that the reason her children were not in Washington, D.C. was because of the defendant and his lawyer. The Commonwealth's theory is that the defendant was aware that Anna was in a relationship with a man in D.C., realized that their marriage was likely to end if the children were moved to D.C. with Anna. It was much less likely that his sentence would be home confinement rather than imprisonment, and he would inherit substantial life insurance proceeds if Anna was dead. The defendant told the police that he believed that he would not be sent to prison if Anna was not available to take care of his children. He told police, but that's all been put under the suspense because of this. So why don't you talk for a second about, in plea negotiations in federal cases, if you're trying to get home confinement, how important is it if you're your children's only caretaker?
Well, it's important. It's a consideration. Pre-sentence reports put that in there for the judge to see. But in this case, he's not. And that's why, you know, this is not a slam dunk for a probation or a not incarceration sentence, because they have another caregiver. They have the mother. And the mother gets interviewed by probation too. And it certainly looks like the mother is willing to take care of the children. So regardless of where the mother is or where the father is, probation is going to report there's another caregiver. I don't think this is going to be a real good slam dunk argument for him getting probation. But again, you grasp at straws when you're trying to keep out of prison. So he's grasping at a straw here, using everything he can in order to stay out of prison.
Well, you know what would make him the only caretaker is if Anna disappeared, which
that's right.
Here we go. All right. So what do they seek to introduce from this case? In May of 2018, the defendant was charged with wire fraud. Okay, we already saw that. Conditions of release were sent over. FBI agents took buccal swabs. Tracy Miller filed an appearance. Defendant pled guilty. Motion to continue sentencing filed on July 13th. Notice of rescheduling sentence hearing entered on October 5th. Further sentencing hearings were held on October 6th and 8th and June 9th. The defendant was sentenced, and the sentence included a mandatory $300 special assessment and restitution in the amount of $475,000, for which $95,000 was deemed paid. The Commonwealth seeks to introduce a redacted copy of the federal docket during the testimony of FBI agent Cook, who has knowledge of the proceedings. Then we get into argument. Evidence of other crimes is not admissible for the purpose of proving bad character or propensity to commit crimes. We can all agree there. Evidence of a defendant's prior bad acts may be used where the evidence of the bad acts is inextricably intertwined with the description of the events of the charged offense. Put another way, the prosecution is entitled to present as full a picture as possible of the events surrounding the incident itself. Evidence that the defendant was awaiting federal sentencing, owed federal restitution, and was facing federal incarceration is inextricably intertwined with the conduct charged in this case and is necessary to provide a complete picture of the relation between the defendant and the victim. Because the federal charges, he was unable to relocate to D.C. We already kind of mentioned that. They argued about the reasons why he couldn't be in D.C., the reasons why he and Anna were having these problems. The monitoring on the federal charges shows that his false statements to police about where he went on January 1st were not the result of accidentally or mistakenly not keeping track of his own whereabouts. So that monitoring may be important for some of the lies that he's going to be caught in for what he told police. And then could you imagine lying to police about where you were, knowing you have a tracking monitor on you? Like, this guy made this is like on Dumb Criminal 101. This guy's like,
he's a brilliant guy.
Yeah, it's brutal. The attorney's comments, which we've already talked about, they want to get into. Buccal swabs that were taken. I don't know if it's just me, but I'm always a little wary when it comes to buying seafood. But today's sponsor, Wild Alaskan Company, takes all the worry out of buying and eating your seafood. Last week, we ate the salmon and it was absolutely amazing. It's so meaty. My kids love it. And literally tonight, we're going to try their halibut. I couldn't be more excited. Some people don't know the importance of 100% wild caught and never farmed seafood. This means there are no antibiotics, GMOs, or additives, just clean, real fish that support healthy oceans and fishing communities. And what's the best part of any product? A 100% money back guarantee. If you're not completely satisfied with your first box, Wild Alaskan Company will give you a full refund, no questions asked, no risk, just high quality seafood. And I'd be shocked if you didn't like it. Not all fish are the same. Get seafood you can trust. Go to wildalaskan.com/lawyer for $35 off your first box of premium wild caught seafood. That's wildalaskan.com/lawyer for $35 off your first order. Thanks to Wild Alaskan Company for sponsoring this episode. Okay, then inextricably intertwined is number one. And then, like you said, motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake or lack of accident. Although the Commonwealth is never required to prove a defendant's motive, if there is evidence of the motive, that evidence is generally admissible, which is similar to the Alex Murdaugh case. His financial crimes came in as motive for why he took the life of his family members. Very similar here, that this federal case, these federal charges, his pleading guilty, this pending sentencing, was the motive as to why he wanted to take his wife's life. And that's always going to be allowed. But how does the state explain it? That the defendant was charged federally, had pled guilty, was awaiting sentencing, and anticipating a significant restitution order is relevant to his motive, opportunity, plan, and the absence of mistake or accident. The defendant was facing committed time, but as he and Attorney Minor suggested, his being the primary caregiver for the children would be helpful to a sentence of home confinement rather than incarceration. Evidence of insurance policies will show that the defendant stood to inherit substantial funds upon Anna's death. Funds that he could use to pay the hundreds of thousands of dollars he owed in restitution is relevant to motive to kill Anna. So it's not your normal greed motive, but it's motive to pay off the restitution that I know I'm going to owe. Evidence that if he remained the primary caregiver for his children instead of Anna taking them to DC with her to live is also evidence of his motive and state of mind. The probative nature of the evidence of the federal charges the Commonwealth seeks to admit outweighs any risk of unfair prejudice. This is one of the biggest parts here. So on the first two sections, what do you think about inextricably intertwined and evidence to prove motive?
I think the inextricably intertwined, to me, is a tougher argument than motive.
I agree 100%. I think motive is by far the easiest argument. I think this is about as good of a motive argument as you can have.
Right. So that's where I would, stress. I would stress motive. And, because in Massachusetts, all you've got to do is something that merely suggests a motive. You don't have to prove motive beyond a reasonable doubt. You don't have to prove it by the greater weight of the evidence, just a suggestion of motive. And they've got a great idea here. A great argument for a suggestion of motive. So I think the motive part is going to get them. I don't know if it'll get them all the information they want from the federal case, because they had a bunch of docket entries there that I really like, the swabs and stuff. I don't even know why they have to put the swabs in, but I do think they're going to be able to get into it because it does certainly give them a motive.
Yeah, I agree. I'm going to hold until we kind of talk about what we think the judge is going to do or what we would do to dig into that a little bit more. Okay, next, let's get into the weighing the probative value versus unfair prejudice. When reviewing a judge's decision to admit such evidence, a reviewing court considers, 1, whether the trial judge carefully weighed the probative value and prejudicial effect of the evidence introduced at trial. 2, whether the judge mitigated the prejudicial effect through proper limiting instructions. 3, whether the challenged evidence was cumulative of other available evidence or admissible evidence, therefore reducing the risk of any additional prejudicial effect. And 4, whether the challenged evidence was so similar to the charged offense as to risk the propensity reasoning the jury. When balancing the probative value against the risk of unfair prejudice, the fact that the proposed evidence goes to a central issue in the case weighs in favor of admission. Massachusetts courts have routinely held that probative value of evidence of a defendant's prior criminal involvement can outweigh the risk of prejudice. And then they cited a couple cases. Probative value of evidence of a defendant's prior incarceration to show identity and motive outweighed the risk of unfair prejudice. Probative value of the evidence of a defendant had previously been incarcerated, highly relevant to the nature and history of the relationship between parties, and outweighed the risk of unfair prejudice. Letters defendant sent from custody, relevant to show nature of relationship between the defendant and the victim, and thus outweighed the risk of unfair prejudice. So to me, that's how they're getting at, there were problems the defendant knew about, problems connected to the federal charges, and therefore they all need to come in. All right. So what do you think is going to happen with these federal charges? Do you think they're going to come in?
Well, a couple points. First, appellate courts don't like other criminal acts to come into a trial.
It's actually usually a very good appellate argument.
Yes, it is one of the most reversed. It's one of the most reversed arguments is when a judge lets in another bad act. Courts really look at that carefully because they know, like you said earlier, they know statistically what that does to the jury. And they know statistically how convictions come out when other bad acts come in. So they really look at those close. So, but I think, again, if you just want, again, my opinion, you're asking for it. I think that the motive argument is a really good argument. I think that they'll be able to get in a bare bones information, not all the detail I think they want to get in, but they'll be able to get the bare bones in order to show enough so that they can establish the motive.
And that's what I was, and that's why I was mentioning the actual charges themselves. I don't think should come in. I think it's very easy to say he had charges, he had to pay restitution, and he was on ankle monitoring to get in the information for motive, opportunity, and relationships and what they all want to get into, what was causing the stressors in their marriage, why he would need to be the primary caretaker, why he would need her insurance policy. I do think they are going to come in. I think the judge will allow them to come in. I actually do think it's fair for them to come in because the timing of when all of this was happening, the fact that they have the ankle monitor. I mean, from my perspective, anytime, and also you can make the argument for motive, the normal greed argument for getting insurance payments from life insurance, because once you're convicted of a federal crime, it's hard to make money, especially these types of crimes. So I do think that they are relevant. I do think they should come in this case, but I think they should be very, 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 like you said, bare bones, inoculated, whatever the verbiage is, to really try and temper how serious this sounds. Because if a jury hears, oh, this guy's a federal felon, it's like, you're cooked. And it's really hard to get over that type of a title as a defendant.
Well, come on. He had an ankle monitor. The ankle monitor is going to be very relevant to the testimony and to the evidence. That they can't keep the ankle monitor out because it shows where he is. Well, you got to explain the ankle monitor. And so that explanation leads into pending federal charges, which leads into the motive. So some of it's got to come in.
And it also leads to consciousness of guilt. He knew he had the ankle monitor on because of the federal charges. He knew what it's like to be on probation or being watched, and he lied to the cops about where he was while knowing he had the ankle monitor on. All that stuff does go to criminal intent. It really does. And the consciousness of guilt and the mens rea, I mean, all of that is relevant in my opinion. The next two are about the victim's out-of-court statements. A lot of it has to do with her relationships, talking about the defendant. Does the defendant know about these relationships? The people she was having an affair with, what was she telling them? What were they saying? Some text messages and other statements. What did you think about these motions?
That one, I think the judge is going to have to take really statement by statement, because the problem you've got, did the defendant know about these statements? Did he know about this information? The mere fact she said something should not be used to convict somebody of a crime unless he knew she said it, because then it could affect him. So that's going to be the issue the judge is going to have to realize is there's not going to be any direct evidence, but the state's going to show circumstantial evidence that he must have known about her state of mind because of the way he was acting and because of the things that he said. So some of it may come in, but that's going to be the issue, is proving that he had knowledge of it.
Yeah, because just because she had an affair seems relevant. If he didn't know about it, it didn't affect his mindset and it wasn't his motive for the crime. So that's the same thing. If she had a gazillion dollars in an offshore account that he didn't know about, well, he didn't kill her for that money because he didn't know she had that money. So it wouldn't make it relevant. So yeah, I agree. Next is the internet history, which is another one I want to read through real quick. It's pretty short, but this is some of the damning evidence in this case. And can you think of a reason how the defense would keep this out? So here's some of the internet history the prosecutor wants to get in. His searches, he was accessing information about these topics, including but not limited to divorce, including jurisdictions perceived to be favorable to men in a divorce proceeding, and divorce laws in Washington, D.C. The man with whom Anna was having a relationship with in Washington, D.C. Ding, ding, ding. P involving a cheating wife. Disposing of human remains. Decomposition of a body, embalming a body, how long before a body starts to smell, and type of person who dismembers a body. Identifying human remains, how to use certain tools to dismember a body, cleaning and chemical agents to clean blood and biological materials from a residence, scouting locations to dispose of evidence, length of time retail stores keep surveillance video, using accounts to collect inheritance from a missing spouse, and declaring a missing person dead. Destroying a SIM card, disposing of a cell phone, disposing of a computer, ability of law enforcement to track suspects through phones and internet history. Dumps in Cohasset and Hingham. Personnel at Tishman, Spire, and buildings managed by Tishman, Spire. Apartment buildings, real estate in Massachusetts, Maryland, and D.C. Lowe's, formaldehyde. Police use of cadaver dogs in dumps. How long does DNA last? Is it possible to clean DNA off a knife? Can identification be made on partial human remains? Device looked at discovermagazine.com/thesciences/want to get away with M, use a special detergent, how to clean a crime scene, how to use hydrogen peroxide and blood stains, concrete, Anna Walshe dead and Anna Walshe missing. Well, what do you think of these coming in?
Well, they would come in if they're able to connect them to the defendant. Here's the problem that I think they're facing. and why the judge may say, yes, these would be relevant, but you have to come over the hurdle or accomplish the task of proving that it was the defendant that did the searches. I notice they carefully say in the motion, the internet history shows that the devices were accessing information. The devices were found inside the defendant's residence. Can they prove that the defendant actually made these searches? Did he actually do it? And that's going to be the hurdle the state's going to have to overcome. Everything they say here is relevant, but again, they have to have the first hurdle.
I believe that some of these were done on his son's iPad. Like some of these were on his son's iPad to try and make it seem like it wasn't him. If you want my guess, all of these are coming in. That would be my guess.
Well, I'm saying the judge is going to have a tough time ruling on this motion based on the allegations of the motion.
Yeah. Next is a motion limiting to admit evidence. The defendant's mom hired a PI to follow Anna.
I think that one might come in because I think that they also said that she communicated that to him, and they have evidence of the communication between the mother and the defendant telling him that she hired an investigator. Plus, I believe that somewhere else I read that the defendant denied knowing that the mother beforehand had hired an investigator. So when he talked to law enforcement. So I think that that's coming in.
And that obviously is relevant to suspicions of affair and other reasons that would go to motive as well that we've already kind of talked about.
Right.
The next one is to introduce a blank calendar as a visual for jurors to just point to like the days of when it happened. There's no problem there.
No.
And then next is a supplemental juror questionnaire. So both sides want to dig into what the judge is going to ask the jury. The defense, we're going to read a little bit about how they want to do individual lawyer voir direing like we usually get to do in our cases, but it seems like the judge mostly controls it, similar to Karen Reed's case. And the Commonwealth requested the following topics to be addressed. And I want to go through them and see if you have any issues with any of these topics. First is, do you have any previous experience as a juror or opinions on the jury or criminal justice system, courts, judges, defense attorneys, prosecutors, the Norfolk DA's office, police, FBI, or law enforcement in general that would impair your ability to be fair and impartial to both the Commonwealth and the defendant in this case?
No problem.
No problem, but I absolutely think they have added the DA's office, and they're really stressing this because of Karen Reed's case, because we are in Norfolk County. It really feels like that to me. Because we always ask about this type of stuff, but this one feels pointed. Next is, have you ever been involved in a group, community, or individual activity that was critical of or supportive of police law enforcement? No issue?
No issue.
Have you or anyone close to you been a victim or accused of committing a violent crime? No issue. That one always comes in. Would you automatically believe or disbelieve police officers or FBI? That's also a common one. You will hear evidence about an extramarital relationship. Knowing this, is there any reason why you would not remain indifferent or any reason why you could not be a fair and impartial juror? What do you think about that one?
Fair question.
The reason I think they want to ask this is some people hate their spouses so much they would do the worst to them when they find out they're in an extramarital affair. So the prosecutor wants to know because they don't want anybody that might have some jury nullification being like, she got what she deserved, basically. Do you have any religious or philosophical beliefs that would make it difficult for you to follow the law and reach a verdict in this case?
No problem.
Do you think you have read, seen, heard, or discussed anything about this case? No problem. Do you know or recognize anybody today in the courthouse? Is there any reason why you'd be unable to follow the instructions during the jury service that you may not read, watch, or listen to any news, media, or social media accounts about this case? Discuss this case with anyone, research or read about this case on the internet. What do you think about that one?
That's no problem. In fact, most of these questions, at least here, the judges ask most of these questions without us requesting them.
Yeah, I don't know why these are considered extra, but I will say that number 9 to me feels like the prosecutor trying to pacify the change of venue arguments. It's like, look, these jurors all said they're not going to look at anything. They're not going to follow anything. They won't hear anything about the case, which is basically what you have to do to try and pacify that because there is going to be publicity here. The last one from the Commonwealth is just preliminary request for some jury instructions on the charges. We don't really need to get into that. Defendant's first request is to sequester the witnesses. I don't see any issue there. Second is they want a jury view of the Walshe house. What did you think about that? I
don't necessarily think that there's a need for that. If I was a judge, I'd deny it because first off, the motion again, so vague. But I just don't see that they've established any need for it. Plus, let us not forget, there is no body and there is no allegation, as far as I know, that the crime actually occurred at the house. So I don't know why there'd be any relevance to viewing the house.
I could see some relevance based on where they found certain materials or certain things or damage done to the house based on some other motions that they write. But it is a logistical nightmare. It costs money. It takes time to do jury views. So it does have to be necessary. And it also has to be something that like pictures can't solve. And that's another thing, that there's probably going to be a lot of pictures of the relevant portions of the house that are probably going to solve this issue. So I could see it going either way, but I tend to agree with you. Defense number 3 is they don't want law enforcement to be able to refer to any biological material or things found in the dumpster as bone because it's speculation, not appropriate opinion, and they didn't do any testing. What did you think about that motion?
I didn't understand that. I mean, I understand the motion, but I certainly didn't understand that no one did any testing or that there is no direct evidence that this was bone or biological material. That just, again, I don't know what the prosecution's got. I don't know that much about the case, but other than reading these motions, but doesn't it shock you that they didn't do any testing?
It does, unless it is so obviously a bone. It does shock me that they wouldn't do testing to figure out if it was Anna's bones, or if it was just too small and they couldn't. And if it is too small, so here's the thing. Cops are allowed to say, I collected what looked like a bone. Okay. They are allowed to say things like that with their personal experience and knowledge and, something that is obviously a bone. But they're not allowed to say this little white chip could be a bone because it could be a million things if you don't test it. So it really depends on what specifically the evidence is. It's kind of like the presumptive test for marijuana, right? It's like you're looking at it, it's like this is clearly marijuana, but there are things that you can testify and things that you can't testify based on your observation, kind of like speed. They were going fast. I would estimate X amount of speed, right? Sometimes judges will allow to be like, well, people know how fast 40 miles an hour are. Sometimes they're like, no, if you didn't gun it, you can't testify to it. So sometimes personal experience can allow you to testify to things like this. But I think this is really going to be fact dependent on what exactly was found, what testing was done, and who was the one looking at it, calling it a bone.
Well, according to the motion, there was no testing done on it.
Right.
So that shocks me.
Yeah. That again, if it is an arm bone, I think the judge will be able to say, I think the judge would allow a cop to say it is what looked like an arm bone or something like, even with no testing. And then the defense can cross-back. You didn't test it. You could have tested it, but you never tested it. So you don't know if it was a bone. And that opens up, some issues on cross.
Again, we have no body. So, it would be tremendous evidence to test this and find her DNA on it. I don't understand it.
But maybe it's bad police work. We've seen that in Norfolk County before.
Yes.
Next is the opinion of Peter Capozzoli, who's caused damage to the home. On who caused damage to the home? Was it law enforcement? I didn't fully understand this because I haven't read the report of Peter Capozzoli or anything like that, so it's hard for me to kind of give a guess here.
I agree. I didn't understand it either.
Next is number 5, to exclude commendations or awards from law enforcement personnel during testimony. What do you think about that one?
And that happens a lot where the judge, judges sometimes let it in, sometimes they don't. But just to build their credibility, normally judges don't let it in.
Yeah, this is completely judge dependent, in my opinion. I don't think it needs to come in. They're cops. The jury sees them as cops. That's all they need. They don't need to know they're cop of the year or Superman or Superwoman. Defendant 6 is any opinion that Brian Walshe knew about the extramarital affair.
Well, again, I agree that's evidentiary. If it's just an opinion, but not based on fact or not based on evidence, just an opinion shouldn't come in. I mean, it's got to be fact or evidence. This is a basic evidentiary rule about opinion. So I don't think that, I think it's going to be granted.
Yeah, I think unless there's evidence that shows he did know about the affair, and if a cop is looking at a text message where Brian Walshe says to his mom, I think Anna's cheating on me, like that's obviously going to come in if it exists. But like, yeah, by the way he was acting, I think he knew she was having an affair. That's not going to come in.
Right.
No expert opinion testimony that has not been noticed or provided to the defense. Again, this is like literally just a rule. Like you have to notice this stuff. If it's not noticed, it doesn't come in, but sometimes lawyers like to file motions to limine like this. Number 8, can't discuss the defendant's request to consult with prior counsel or statements of prior counsel. So I did want to read this one. And it's a little blurry, so I will read it the best I can. Let me do this. All right. To exclude evidence of 1, the defendant's request to consult with his then present counsel, Tracy Minor. 2, any statements of prior counsel contained in the recorded interviews of the defendant. And 3, any statements of prior counsel made to any third party, included but not limited to law enforcement or the district attorney's office during a representation of the defendant. A defendant's request to consult with counsel is inadmissible. The defendant's request to speak to his then present counsel is not relevant, contrary to the law, and therefore inadmissible. The presence of and statements made by defendant's then present counsel during the questioning or at any time prior to and after his arrest are not relevant to any issue and inadmissible. The defendant's request to consult with counsel and his counsel's comments are prejudicial without any probative value. Again, these are very vague, but generally you get the idea of what they're trying to keep out. What did you think of this one?
Well, number 1, the request for counsel. I've had that exact issue come up in a case, argued it and won it because excuse me.
I said, as you should win, because that should not come in.
Right, because that's a Fifth Amendment right to counsel. The fact that you ask for a lawyer should not be used against you in the trial, and that's what they're trying to do. So number 1 should definitely not come in. Statements of prior counsel contained in the recorded interviews. We talked about this a little bit earlier in that prior motion. It's going to depend on what he said or what she said. I think it was a she. What she said and whether or not it was adopted by the defendant or not. That's going to be the crucial issue. And the third one, any statements of prior counsel made to any third party. Again, it's whether or not it was an adopted admission or just the lawyer talking. Because everything, again, a lawyer says doesn't necessarily mean it's adopted by the defendant. So this is going to be something the court's going to have an evidentiary hearing on. It's probably going to be ruled on during the course of the trial.
This is just the inverse, basically, of the Commonwealth's motion.
Right.
And speaking of that, the next one is the motion regarding prior bad acts. The defendant has filed a motion for any such evidence without any response thus far from the Commonwealth. Specifically, the defendant moves to exclude any such bad acts evidence, including but not limited to the uncharged 2011 allegation contained in an out-of-state police report, evidence of fraud and scheme and a federal conviction, and uncharged allegations of the defendant's mishandling of his father's estate following his father's death. The defendant states through counsel that evidence of purported bad acts, before it can be introduced, if it even exists, must be shown to be relevant, and even if relevant, its probative value must be weighed against its prejudicial value. What's more, such bad acts evidence not properly admitted is nothing more than bad character opinion evidence that should not be admitted in any form. Okay, again, incredibly vague, asking that the court exclude the prior bad acts evidence. And then they cite 404B. What do you think here?
Again, they're just throwing it out there to put the judge on notice that this stuff's coming in and we're going to object to it. I don't think the judge can give them a ruling on it based on just what this motion says. My guess is that it's something the judge is going to reserve ruling on. And, when it happens, and rule on it then.
Yeah, this is just such a vague motion. If I was a judge, there's no way I could say, okay, this bad act comes in or this bad act does not. But these are all going to be things that are going to be fought about throughout the case. I do think the judge is going to have to make some kind of call on the federal charges and what is going to be able to be brought in. Because if I'm the state, I'm going to want to talk about that in opening. Exactly what was happening, how he got caught, what he was doing, why he wanted to do it. So I do think that the judge is going to have to parse through some of this before opening statements. So this final pretrial hearing where they argue these motions in limine is going to be very important.
Or the judge, and judges have done this, told them, look, stay away from that in your opening statement. Yeah, so, and it hurts.
I would not be happy about that as a prosecutor. Right. I would not be happy if that was the judge's rule.
But judges do that. They say, look, just stay away from this issue until I rule on it, and I don't have enough facts to rule on it. So, the judge might do that.
Yeah, I think you can proffer. Hold on one second. All right. So next is witness characterization of evidence and speculating. I'm going to put that one up here. They want to exclude witnesses' conclusory characterization of the defendant, his behavior, and to exclude same such evidence from criminalists regarding speculative opinions as to what was observed, collected, or tested. The defendant requests to limit any of this testimony, and he specifically says things like, throughout the discovery produced in this case, discovery includes various statements of witnesses and of a criminalist or law enforcement who are involved in the investigation, various statements that include but are not limited to where a witness's belief that, 1, an observation they made was weird, or similar terms. 2, where a witness characterizes an interaction he observed as coaching. Or 3, statements attributed to Anna Walshe wherein she reportedly stated, paraphrased here, that she did not know what her husband was capable of. Or 4, that discoloration of a section of the bedroom floor in the Cohasset home appeared to have a white residue or the finish had been scrubbed off. What do you think about this type of characterization of evidence?
Well, I think the law, just like the motion before it, they're correctly stating the law. They're correctly stating, Judge, it shouldn't come in because this is what the law says. But so I think they're correct in their statement of the law. It's whether or not during the course of the trial, the judge hears evidence that allows something to come in. That's a different story. But there certainly is no argument that they're correct. Bad acts are not supposed to come in, or opinions or characterizations.
Yeah, I definitely think like that was weird, shouldn't come in. But certain things like he was being coached, I think that the judge might allow certain things like that. If like the lawyer's like, say this, say that. I don't know what the details are, but depending on what the details are, I could see something like that coming in. I could also see something like there was discoloration on the floor. Was it consistent with somebody scrubbing a floor? Have you ever scrubbed the floor before? Yes. If you scrub it too much, it looks like this. I could see them potentially getting into that. I wouldn't like it as a defense attorney, them making those conclusory statements. Maybe it would be too prejudicial based on, their understanding and how important if something was cleaned up and scrubbed off in this case. I could see a judge saying no to that. But personal experience by law enforcement officers and witnesses is usually allowed and wouldn't necessarily be considered speculation.
Yeah, but the problem with the motion is, the motion correctly states the law, but you got to take the law to the facts. And so we don't know the facts and circumstances to back up what they're talking about.
Right. And that's a problem. I mean, that is a problem with these motions is if I'm the judge, I'm a little annoyed too. I'm like, I couldn't do any preparation beforehand because I didn't know what specific facts you were trying to tie in and why this person doesn't have experience to be able to say this and who even said this. Just to say witnesses and criminalists and whatever say all this stuff, like it matters. Right? If it's somebody that is a DNA expert and is the one doing the crime scene investigation and knows what it looks like when a scene has been cleaned up, they might be able to testify to it versus, I don't know, a beat cop that just showed up to secure the area and put up the tape. So it does make a difference who said these things. Next is the Commonwealth has to provide notice of what internet searches they intend to introduce. This is something that if it's going to be an exhibit, if it's going to come into evidence, if it's in discovery, this is fair for them to want to know what searches are going to be introduced, especially if they have arguments against specific searches.
This one is, again, there's no rule. This one is a matter of fairness where the judge says, look, you've got 10,000 internet searches here. It's unfair for the defense to have to prepare for 10,000 when you know which ones you're going to put in. So you have an unfair advantage. So the trials aren't supposed to be about someone with unfair advantages. So why don't you go ahead and give it to him? I think the judge is going to grant that.
Next one is the attorney conducted voir dire and some additions they want to make to what the judge asks, or if the attorneys can ask the jurors, which I thought was interesting. Let's read through the requested panel attorney voir dire topics. The effects of graphic testimony and photographs regarding purported body parts, including purported tissue, blood clot, skeletal muscle, bone, video of the purported distribution of materials of a deceased spouse, of biological evidence found at various locations, including trash collection locations, and found in the basement of the home, and the ability to remain fair and unbiased and impartial. Any issue with that?
No, except they talk about bone there, but no.
I know, it's like, are they going to be able to say it is or no?
Yeah.
Testimony and evidence of various tools purportedly used to dismember a body. No issue.
No.
Domestic violence issues. Violence alleged to have occurred within a family home, infidelity, and the effect on relationships. Both sides seem to agree on that. What motivates an otherwise reasonable person to act in a particular manner? That's an interesting one. Any issue with that?
I really don't, except I think it's a stupid question. But I mean, if they want to ask it, they can ask it. But, that really is a stupid question, because you know what? If jurors are allowed to answer those questions, it opens up the possibility of infecting the whole jury pool.
Right.
Because one person might think something's a motivation where another person might not. So, when you ask open-ended questions like that, you can infect the whole jury pool. If I was a judge, I don't think I would allow a question like that.
I would definitely not. I don't mind asking open-ended questions and getting the jury talking. And if they are poisoned, I would want to know as a criminal defense lawyer if they are all sitting there thinking my client is guilty. But this type of question to me is just not the right type.
Oh, look at the next one. Look at the next one. Same thing.
The effects of exposure to unrelated and shocking allegations of homicide. I mean, I can understand if they want to ask, just because these allegations are so bad, do you automatically think he's guilty, or do you feel more of a need to convict? I'm okay with that. The effects of publicity, broadcast, social media exchanges about cases of domestic violence, such as what occurred in this case beginning in 2023 and thereafter. No issues with that. The ability to be objective.
Except think about what he's saying to the jury there. He's giving the jury, basically telling them, look, my client's a domestic violence abuser. At least that's the way I interpret the question.
Oh, he actually mentions Turtle Boy here, which is interesting. I didn't recognize that the first time I read through. That's interesting. The ability to be objective in the face of hearing shocking information. Okay. Principles of law and respective jurors' willingness to the ability to accept and apply the law. No issues there. Police officer credibility. No issues there. Reasonable follow-up as to responses. He wants to actually be the one to ask the jurors the questions, which I don't have an issue with, but they seem to in Massachusetts. Any issues or surprises that we didn't mention with the defense's voir dire questions?
No.
Then they also talk about preliminary instructions to the jury, which to me were also pretty standard.
Right.
No real issues there. And the last part was they asked for funds for rushed transcripts. No issues there, but I don't think the judge is going to allow that. What do you think?
I was going to say, I don't think the judge is going to allow it.
Yeah, I don't mind him asking for it, but I don't think the judge is going to give them rush transcripts. That's very expensive. And even people that don't have court-appointed lawyers don't usually get that if it's so expensive. And so usually they try to give you everything you can for a fair defense, but they're not going to go above and beyond with what they allow as far as court-appointed funds or public defender funds.
Right. And you look at all these motions, and a lot of them, it's going to be tough for a final decision to be made based on the motions. It's going to be in trial that you're really going to hear the final decision. And keep in mind, it's going to be tough for the prosecutor because they do have a hurdle in that there's no body. So, that's why they want to get all of this stuff in.
Yeah, there is a hurdle. But to me, as I've looked at this case from the very beginning, this guy was so dumb in every step that he made that it just seems like there is so much evidence against him. And his lawyers have filed motion saying, people are saying that on the internet. People are saying he's guilty. People don't care about the presumption of innocence. We obviously care very much about the presumption of innocence, but what has been reported does look bad for him. We always say, keep an open mind as a jury. When you walk in, see if the prosecution can actually prove this. Just because you've heard something doesn't mean it's going to come in at evidence, doesn't mean they're actually going to be able to prove it. And we still feel that way with Brian Walshe. But if the federal charges, the internet searches, the ankle monitoring, the statements he made all come in, it's going to be a very difficult and uphill battle for Brian Walshe. And guess what? That's just the truth sometimes. That's just how it is sometimes for criminal defendants in the situation they find themselves in going to trial. So doesn't look great for him, in my opinion, right here, but we'll keep an open mind going through. What were your thoughts kind of as the motions as a whole and your thought going into the trial and into the case?
I thought the motions as a whole could have been, well, I hate to say it, better written. I think that they could have put more facts in if they really want the judge to rule in their favor. Otherwise, or they just didn't have the facts to put in those motions, which like the third-party culprit motion. Maybe there just isn't a third-party culprit, but they just filed it. And I think a lot of these motions are like that, especially the really vague one that put no facts in. The long ones, like the ones you went through, those are the ones that matter. And that's why they spent time to put facts in those. So I think you've got two sets of types of motions here. You got the ones that don't matter, and you can tell by the way they wrote them, they don't matter. They don't matter to the lawyers. And then you got the ones that do matter, and those are the longer ones. So again, a lot of these motions, I think they didn't have to file because, like you said, they're the rules. And so you don't have to file motions that just go through the rules or to tell the judge what the rules are. So I think they could have cut these motions in about probably half.
Yeah, I also think the defense didn't do a good enough job at coming up with arguments to try and get rid of some of the really damning evidence. Like show us why these internet searches should not come in. Show us why his ankle monitoring or where he was shouldn't come in. Show us why he was coerced into talking to the police and he really shouldn't have, and those should be suppressed, whatever. I know they've done a lot of that in the past already, so maybe they just feel like they don't need to repeat it in the motions of limine. So, but I just feel like all of this kind of shows maybe there just aren't the arguments. Maybe the arguments just aren't there. Maybe the defense attorneys didn't miss them. It's just that this stuff's coming in.
Well, the one on the notice of internet searches, for example, if I was, let's say there's 10,000 searches, which there certainly could have been. We've seen cases that have that kind of volume. I would have put in there, Judge, look, here's a search for Mickey Mouse. And here's a search for Disney World. And here's a search for a trip to Paris. These are just examples of the stuff they gave us in discovery. How are we supposed to know what they're going to use? And I would have put some examples in there of the irrelevant searches that are in that group so that the judge can make a decision.
Yeah, I agree. Because that's really how you fight to win, to get some of this stuff kept out.
Right.
All right. Anything else as we go forward to the trial? Plan is hopefully for you to be able to follow it as well, so we can do weekly podcast updates on this trial. I think it is going to be interesting. I think we will see some good lawyering throughout. And of course, it's Norfolk County, so you never know what to expect. But that's all we got for our gear up for Brian Walsh's trial and the pretrial motions. We'll see how the judge rules and how it affects this trial once we get there. But that's all we got. Till next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.